These seminars typically take about an hour and a half to get through, but we realize that you all just don't have that kind of time in your day to give up. So we created this abbreviated version to provide you with only the very essential information. So I have a lot of material to get through in 15 minutes. So please hold your questions until the end, and then I promise I will stay on as long as necessary to get all your questions answered. And you can actually type your questions in as we're going along in the seminar as they pop in your head, and then we'll take those at the end. And Kathy, if you could tell them where the box is for them to do that.
If you look on your control panel, there's a tab that says Questions. If you click the plus sign, the box will expand and you can type in your questions. Please keep in mind that you can type questions during the webinar, but Tony will answer them after the webinar.
Okay, thanks. And also, I'll let folks know that we're having a little bit of audio difficulty in our headquarters office today. So if you experience those problems, please text that in the box so that we know what's going on and we can troubleshoot it right away. Okay, liability exposure for all federal employees really began back in June of 1971 with a Supreme Court decision called Bivens. And this was the very first case that allowed federal officials to be sued personally. And it was in response to this ruling that the concept of liability insurance was really created. And also, this is in response to this, Congress passed legislation requiring agencies to reimburse certain groups of employees up to 1/2 of the cost of the annual premium for professional liability insurance. The groups of employees are managers, supervisors, and law enforcement officers. As medical officials, often you all are described and defined as managers and supervisors. Therefore, this legislation, this reimbursement, would apply to you in that capacity. I like starting the presentations with this slide because it's really important for you to appreciate that this official support by Congress is really their understanding that there are risks associated with your federal employment that cannot be completely cured with legislation. They understand that you need liability protection, and they want to share the burden of the cost with you. I should also mention here that the liability insurance is available to all federal employees, so don't worry if you're not a manager or a supervisor and you're asking yourself whether you're eligible for the insurance. You are eligible. You just may not be eligible for the reimbursement, which has specific designations of manager, supervisor, and law enforcement officer. If you have questions about whether you would be eligible, you can contact your agency's HR office. You can search your intraweb in the agency and look for the professional liability insurance reimbursement policy. Usually find it, or just give us a call. We'll give you a number at the end of the presentation, and we usually have pretty much every major agency's liability policy on hand, and we can provide it directly to you and hopefully answer your question. So think of liability insurance in terms of 3 categories: civil, administrative and disciplinary, and criminal. So it's civil, administrative, and criminal. The liability insurance provides a defense against the civil, it provides a defense against the administrative, and it provides defense against potential criminal investigations. And with the civil, it also provides the indemnity protection in the event that you are sued and found liable. And I'm going to start today's presentation off with the civil aspect of it, because that is the main reason that Congress passed the legislation for the reimbursement. So we like to always start off with that. Unlike physicians in private practice or other medical professionals in private practice, I should mention at the outset that civil exposure is not really the primary reason that medical professionals in the federal government need liability coverage, okay? But it can happen, so it's important that you understand what these civil exposures are. Civil suits in the federal government are often referred to as Bivens actions, constitutional torts, personal capacity lawsuits, individual capacity lawsuits. You don't have absolute immunity for these types of lawsuits like you do for lawsuits under the Federal Tort Claims Act, okay? Most physicians and other medical professionals are familiar with the FTCA, which essentially gives you your malpractice protection for any actions that happen within your scope of employment. There is a carved-out area where you could still have vulnerability and liability, and that's what we're talking about today. These constitutional torts, these violations of someone's constitutional rights. And even though they're rare, they're still important for you to understand. And there's three general concepts we want you to understand with regard to civil suits. It's representation, immunity, and indemnification. First, representation. If you get sued, obviously you want to know who's going to defend me. Surprisingly enough, for a lot of folks in the federal government, DOJ representation is not mandatory. It is not automatic. Most folks are surprised about that. It is the sole discretion of the Department of Justice to decide whether you will be assigned a DOJ attorney to defend you in these personal capacity lawsuits. Even if it's absolutely clear that you are acting within your scope of employment, DOJ must also determine that it is in the interest of the United States to provide you with defense counsel. So let's say you're being investigated for some sort of ethics violation or some sort of wrongdoing for the very same reason that you've been sued in your personal capacity. You can see that DOJ is not going to be on both sides of that. The next concept, immunity. As I said, you don't have absolute immunity for these personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. You only have qualified immunity. The next concept is indemnification. Even if DOJ provides representation, what you need to understand, whether Feds provides it, DOJ provides it, or you provide it on your own, even if DOJ defends and you lose, it's still a case against you personally, so you can still be held liable for the judgment if your agency refuses to indemnify you. And that's where the Fed's policy comes in. It provides you up to $1 million or $2 million, depending on which policy you purchase, to pay this judgment. That is the judgment protection. So just a real quick recap for civil. I want everyone just to understand they can be sued. They can be sued personally. They can be held liable for a judgment, and they can be denied representation. So if you don't have a liability policy, you can be on your own to hire a lawyer to get the case dismissed. Liability insurance protects you in three major ways. We talked about legal defense, and we talked about how it pays damages. Coverage counsel I didn't mention. I'll talk briefly about that. The policy will also appoint a lawyer to supervise Department of Justice representation of you, because ultimately the indemnity part is both of our risks, and we may want to take a look and see how things are going in the case and make sure that your interests are being looked out for. We also would appoint coverage counsel in certain cases where DOJ is on the fence as to whether they want to represent you. We may hire coverage counsel to convince DOJ that it is in the interest of the United States to represent you. So again, before I leave civil, just want to emphasize that it's rare. Civil cases are rare, with actual liability being even rarer. The reason I'm mentioning that, it's probably about 5% of the lawsuits against medical professionals actually end up proceeding in a personal capacity way. The reason I'm emphasizing this so much here is because there's misinformation out there. If you've ever attended an agency-sponsored liability seminar and the attorney or DOJ person doing the presentation question the need for you to get liability insurance, this is what they're talking about. They're approaching it from a civil perspective only. They're not realizing the benefits we're about to talk about, the administrative protections and the criminal protections. And also, they're simply, not acknowledging that there are these few percentages of the cases that, can go directly against you. And believe me, you're not going to want to risk it once you hear how inexpensive the policy actually is. You will spend more for just 1 hour of legal service than what the annual premium is for the Fed's policy. So this is the administrative part of the policy, what we call the administrative expense provision. This is your biggest bang for your buck for most medical professionals and also medical professionals who are also managers and supervisors. It essentially covers you for any of these types of investigations. We're talking any IG investigation, any ethical violation, Office of Special Counsel, HR investigation, management investigation, any disciplinary proceeding. If you're named as a responsible management official in an EEOC complaint, we'll appoint you a lawyer to defend what I call cradle to grave, both at the agency level all the way up to any conclusion of the investigation. In the unfortunate event that there's a disciplinary action taken against you, the Fed's policy provides a defense both at the agency level and to the Merit Systems Protection Board if it's necessary to make an appeal. Please understand that whether your actions are intentional, unintentional, you need to know that you will be held accountable for even the most trivial or justified misuse violation of agency policy. Often I see medical professionals accused of ethical violations connected to research programs, grants, dealing with the public, patients. And what I've found, is you're a doctor, you're a medical professional. You're not an expert in federal personnel law. You're not an expert in what the ethics rules are. You're not an expert, in the financial disclosure rules. And often, the general counsel's office or any other agency guidance really just isn't there for you. So often, a medical professional can very innocently see themselves end up being the subject to one of these investigations. And I should also mention that if a state medical board investigation or proceeding is launched against you for something that arises out of your federal employment, arises out of one of these allegations or investigations that I'm talking about, the Fed's policy provides protection and coverage there, just like a regular malpractice policy would if you were in the private sector. One specific type of investigation I want to just spend a little bit of time on is these IG investigations. I can't tell you how many times I've heard, I didn't do anything wrong, and if I did, surely I can explain to the IG and they'll understand. Or if I show up with a lawyer, they'll think I'm guilty. Applying these concepts without getting proper legal advice, trust me, you're not going to fare well. It's very important if you are notified that you are the subject to an IG investigation that you just don't blindly go into it. You should at least consult with an attorney. If nothing else, just so you can understand your rights. Not every request by the IG for an interview is mandatory. Often they are voluntary, and submitting to a voluntary interview is also a waiver of your Fifth Amendment's rights, which should never be done without talking to an attorney first. So the Fed's policy, as we mentioned, if you are notified that you are the subject of an IG investigation, we would point you an attorney to liaison, deal with the IG prepare you for the IG interview and actually attend the IG interview with you. Similarly, the same protections apply for Office of Special Counsel investigations. These are investigations into whistleblower reprisal or other prohibited personnel practices, usually launched against managers and supervisors, hiring irregularities, or anything that is a prohibited personnel practice. The Office of Special Counsel has the authority to come in and investigate. I like to pull this slide out because often, if you've ever been associated with an OSC investigation, often it feels like it's a case against the agency just as much as it's a case against the supervisor. And so the agency lawyers are on board, and it appears as if your interests are aligned. You need to appreciate and understand that the agency lawyers, their duty of loyalty is to the agency. That's their client. That's who they represent. So while their interests and your interests may be aligned, it could result in a situation where they're advancing an interest that is adverse to yours. So it's always important to get your own lawyer, consult with your own lawyer during one of these kinds of investigations. And again, that's what the Fed's policy is there to do for you. Medical officials could be subjected to congressional oversight, investigations or hearings, whether it has to do with drug trial approvals at the FDA, research that's being done at NIH or the VA, or whether it's patient treatment of our veterans in the VA. Congress sometimes has a particular interest in this, and they can haul you up for testimony. The Fed's policy, which is a pretty scary thing, the Fed's policy will appoint you a lawyer for those kinds of congressional investigation and hearings. The final type of investigation I want to mention here is EEO complaints. I'm often asked, why do I need liability insurance for EEO complaints filed against me? Isn't it a case against the agency, and isn't the agency responsible for defending? Well, that's true. But just like I mentioned for the Office of Special Counsel investigations, the agency lawyers, their duty of loyalty is to the agency. Okay, they defend the agency, so they could be advancing an interest that's adverse to yours. So it's important that you have your own counsel during these EEO investigations. It's also important to have your own counsel explain your role in the process of these EEO complaints. I've found often federal officials are unaware, unfamiliar with what their role is in these investigations. All they know is they get a knock on the door, you get an email from an investigator that says somebody has filed a lawsuit and they want to ask you some questions. Your role in the process is to establish and put forward what's called the legitimate and non-discriminatory reason for doing whatever it is you did or did not do that person's complaining about. That is the piece of evidence that the agency lawyers are going to use to defend the EEO case. And often it's important to at least discuss what that is with your own legal counsel. And that's what the Fed's policy does. This just summarizes what I've been already talking about for these administrative matters, what the policy provides you. And finally, and quickly, the final exposure area is criminal. And I know, look, as federal officials, medical professionals, I know you didn't come to work today, put on your jacket and intend to commit a crime. I get that. But what you need to understand is that there's very little you can do wrong in the federal government and not also have it be a violation of Title 18, which is the criminal code. We often see medical professionals under criminal type investigations for conflict of interest statutes where intent is not a prerequisite to prove the crime, misappropriation of federal funds, other conflicts of interest, release of privacy or other statutorily protected information. Just this morning, I spoke to a doctor at NIH who's got a proposed removal for disclosing some confidential information. They're actually charging him with violating Title 18 of the U.S. Code. Pretty scary stuff. It really can involve any situation arising out of allegations of misuse or abuse of your position or authority. If you are notified that you are subject of a criminal investigation, it is absolutely important for you to talk or retain criminal defense attorney before you talk to anyone. Don't be naive in this situation and think that the matter is just going to go away. Also, as a federal official, you don't have the luxury to sit around and wait for an indictment, wait for them to decide what they're going to do. You really need to have a lawyer actively engaging with the Department of Justice to convince them that this is not a criminal matter, that you ought to let the administrative side of the house deal with it. Here's a little summary of what the liability insurance covers and provides. You know, I've been defending federal employees for almost 18 or so years now, and you know, whether the complaint comes from a patient, a politically motivated official, special interest group, industry, subordinate employee, you know, an employee where you're trying to get a day's work for a day's pay out of and is complaining, you know, or a member of the public, you know, thinking that an investigation requiring legal counsel, thinking that it can never happen to you is pretty naive, okay? It's pretty naive. In today's environment in the federal government, you know, even if, you know, the allegations, you know, are outrageous or completely misguided, most agencies are required to look into them, you know, even if it is just declared a federal official. So it's important to always have counsel on your side during that process. You know, even if you're ultimately vindicated, with lawyer rates going at $400 and $400 an hour, the cost can add up very quickly. And so a lot of people are surprised, even though you're cleared of any wrongdoing, completely vindicated, you don't get reimbursed for those attorney's fees. That comes out of your own pocket. So this is what I'm talking about, the affordability of the liability policy. You don't have to break the piggy bank, as I say. It's only $270 a year. If you're eligible for the reimbursement, it's as little as $135 per year, and we have payroll deduction available, which works out to be $12 a pay period. This is my final slide, and I can't emphasize this point enough, that like your other insurances, home and auto, you need to have the insurance in place prior to the allegation claim happening. The case I just mentioned earlier today, that the researcher, the medical doctor at NIH, who called me this morning and has a proposed removal, he bought the policy after he was notified of the allegations. So, you know, he is unable to get a full legal defense, you know, to defend for that proposed removal, and has ended up probably making a decision where he's just going to resign his federal employment because defending is simply cost prohibitive. There are 3 ways to get enrolled. You can just go online at fedsprotection.com, hit buy now. It takes less than 5 minutes. We can send you our one-page enrollment form, or you can give us a call and we'll get you enrolled over the phone. So that concludes my presentation. I will now open it up for questions.
Okay, Tony, we have a 2-part question. What if I work for the VA? Is there a difference working for the DOJ for liability protection?
No, if I understand the question correctly, is there any difference in the agency you actually work for? No. I mean, you're either a federal employee or you're not. So whatever agency you're at, these concepts apply the same.
Here's another two-part question. I currently have liability insurance. Is this coverage the same, and does it qualify for 50% reimbursement?
Yes, it qualifies for the reimbursement. If you currently have coverage, you have it with one of the other two providers, which I'm happy to mention. One is Right USA, and the other is Career Guard or Mass Benefits. And this, what I'm talking about today is the insurance is virtually, the core insurance protections are virtually the same, identical. We think there are some differences that set ours apart, since we're a little bit cheaper. There are differences with our claims handling, and there's a reason all the federal employee associations are endorsing us over the other two providers. And there's more information on the comparison on our website, and I would, if you're a current holder with another insurance company, I would encourage you to get online and look at that and compare the coverage that you have versus the coverage that we're offering.
Okay, another question is, will it cover me for my private nonprofit jobs as my current private liability insurance does?
No, it only covers you for acts, error, emissions occurring within and connected to your federal position. So if you're involved in an outside separate activity such as a nonprofit, this type of liability insurance does not protect you for that. Versus, and I would think that the one private one you have, but first it also doesn't protect you for your federal position. There's usually exclusions for that, but it may, I don't know. I would mention that if, too often medical professionals are permitted and have to do certain kind of work to keep up with their qualifications in very emergency rooms or other places that are in private entities, but they're doing that on behalf of and with the authority of the federal government. They're still within the scope of their federal employment for purposes of our coverage. It would apply to that.
Okay, here's a question for you, Tony. How often do social workers get sued?
Well, I mean, it really depends. I mean, it depends, what kind of environment you're working in and whether you're a manager, or supervisor. I would encourage you to just call the office and, we can get more information about where you're working, what facility you're working at, and we can answer your question a lot easier. But it really depends what kind of environment you're working in, as whether you're getting complaints from subordinates, colleagues, how disruptive it is. The particular work environment can be different from one installation to another, so it's really hard to answer that question.
Thank you. Here's another question. Is the amount of coverage per lawsuit or per year?
That's a very good question. It's per incident, so it's per lawsuit, or per IG investigation. So let's say Dr. A is the subject of 3 administrative ethical investigations throughout, and they're unrelated to each other throughout the year. You have $200,000 to defend for each of those, so a total of $600,000. The same if you were being sued 3 times in your personal capacity. The $1 million or $2 million is unique to each particular lawsuit.
Another question is, about how many federal medical lawsuits do you handle per year?
It's really hard to put a number, an actual number on that. I would say there are several federal officials, federal medical officials being sued in their personal capacity each year. Whether there's actual liability, it's hard to know, because not everybody has the liability coverage. With regard to the administrative investigations, we typically see, anywhere between 100 and 200 situations where medical professionals are under administrative investigation per year, and those are just our insureds. There's a big percentage of you out there who are simply uninsured, and and the reasoning usually is a false belief that it can never happen to you.
Here's another question for you, Tony. Is the Stratton VAMC already offering me PLI with the Albany, New York?
I'm not sure I understand the question. Is the question saying is the liability insurance being provided by the government?
Yes, that's what he's asking.
Okay, no, it's not. And that's a good question, because we'll get calls like that. People wanting to buy the Federal Tort Claims Act insurance. That's federal law. Okay, that's not being purchased or provided, by anybody for you. That's just straight federal law. This type of insurance is not. It's an individual choice that you have to make. Now, the agency does reimburse you, is required to reimburse you up to 1/2, but the decision to purchase must be yours. And as we pointed out, you have options to consider what type of company or which company you want to go with. It's not being purchased for you, for the agency, for individuals in the executive branch. There are some, congressional commissions and things like that where they buy it for all their employees, but that's something that's a little bit unique.
Thank you, Tony. I have another question. Does it cover psychologists as well as physicians, and is it the same cost?
Yes. It covers, all federal employees the same, and it's all the same cost. It's what we call a program professional liability insurance. We're able to put you all in the same group, so that we can spread the risk, and that's why it is so inexpensive. We were going to compare it to any private sector, type of insurance that you would get, but it covers. The coverage is the same. The core protections are the same. The price is the same. The reason we sort of do these specialized webinars and kind of target and communicate a little bit different to different groups of employees is that each group, really needs it for a little bit of a different reason. And we felt, putting you together in these groups is helpful to get the questions answered that you need. But it applies to psychologists. It applies to all federal employees, medical professionals across the board.
Here's a statement, Tony, not exactly a question, but I'd like to read it. I am an MD and with the VA, and I thought that our VA would cover the malpractice liability, so this is news to me.
Right, and that gets at that statement I at the end of my civil coverage there where I said, the VA, lawyers and things like that will tell you that you're fully covered, and it's because they're looking at it strictly through the eyes of the civil exposure. But there is that, 5 to 10% that could sneak through the cracks in personal liability. And then there's the administrative coverage, as I said, as your biggest bang for your buck. That's going to cover you for employee complaints and complaints made from the public. These are cases where the agency is investigating you, so they can't be defending you at the same time.
Thank you, Tony. I've got several questions up here about reimbursement. How do we apply, and when do we apply?
The way it works is you sign up with us. And we give you, once you pay, we give you a certificate of insurance and a reimbursement certificate. You take that along with, we have a lot of, it looks like a lot of VA doctors on the webcast today. You take that and you turn it in with a form. It's called an 1199. And it gets processed just like a travel voucher reimbursement. You're entitled to one reimbursement a year, and we'll actually send out the VA policy to the VA people on the call so that you can read it there. But it's fairly straightforward. We give you the certificate. You fill out the same form that you would fill out if you took a taxi somewhere to get reimbursed. You submit that, and it shows back up in your pay as a reimbursement, just like a travel voucher reimbursement.
Thank you, Tony. I have a gentleman who has a question who's had his hand up for quite a while, if I can unmute him.
Sure.
Okay, Walter.
Hi, Walter. You have a question?
Okay, sorry about that. I do have another question. Would it cover alleged wrongful termination of a covered person?
If I understand the question correctly, you're talking about a federal employee who's got their liability insurance and is being fired for something that has to do with their job. Yes, that's exactly what it covers. We will provide the defense both at the agency level, the administrative level at the agency, and also if we have to appeal it to an administrative tribunal called the Merit Citizens Protection Board, it also provides a defense there up to $200,000 as well, which the $200,000 is going to get you all the way to conclusion in most administrative cases. So, that's exactly what it covers.
I have one more question, Tony. Who determines if you are a supervisor or a manager? For example, your job descriptions.
Yeah, it's defined. It's defined. As I'm doing this, I'm trying to grab the statute. It's defined in the statute what a supervisor or manager means, and essentially, in the liability legislation, what they did is they mirrored and they referred to the Federal Labor Relations Management definition of manager and supervisor. So what a simple way to look at it is, because of your managerial and your supervisory duties, if because of that you're ineligible to be in a bargaining unit, to be part of a union, then you would qualify for the reimbursement. That's the definition of it. So there's a pretty loose, liberal, if you will, definition of what is a manager and a supervisor. It doesn't necessarily mean that you actually have to manage actual employees. If you're managing programs, policy sort of things, you may still meet that designation. But again, I would refer you to the agency that provides its own interpretation of its own policy. But generally speaking, if you look at your SF50 and you're coded 8888, which means you're ineligible to be part of the bargaining unit, then generally speaking, you're eligible for the reimbursement with the insurance.
Okay, Tony, I have another question. RNs and APRNs can be in the union. Do they still qualify for coverage and reimbursement?
You're still eligible for the insurance. Whether you're eligible for the reimbursement would have to depend upon what kind of RN position you have. If it is a non-supervisory one where you don't supervise, you're not managing other people, you probably are not eligible for the reimbursement. But again, I would ask your agency, HR function. They're very familiar with this question. They've been asked it before. They often have just a code, a group of employees that they know are eligible or are not eligible.
Thank you, Tony. It looks like we're out of questions. Oh, I apologize, Tony. We do have one more. I'm sorry. It is a non-supervisor. This is in addition to that last question that was asked. It is a non-supervisory APRN, similar to a PA.
If I were to venture to guess, I would think you're probably not eligible for the reimbursement. If you're eligible, as you said, to be in the bargaining unit, and it's non-supervisory. But again, ask your agency, because the law is designed to be liberally interpreted. They want as many people who could be vulnerable to get this type of protection. Just because you're not entitled to the reimbursement, however, doesn't mean that you still don't need the insurance. It just means that Congress, in all their infinite wisdom, has not deemed your position yet, as one that gets the reimbursement, or more importantly, your lobby, you weren't able to lobby successfully to get the reimbursement, like the big manager and supervisory groups and the law enforcement groups that have the increased exposure. And at $270, annually, that's a lot of peace of mind for not a lot of money.
Tony, I do have Diana with her hand up. I'm going to unmute her.
Hey, Diana, do you have a question?
No, she doesn't have her audio pin set, so we can't hear her.
Feel free just to call the office after the call, Diana, and we'll get your question answered. 866-955-3337 or 301-229-2481, and we'll answer any additional questions that you may have.
Okay, we are out of questions, Tony.
Okay, I'd like to thank everybody for participating today. Hopefully you learned a lot, and hopefully you'll consider buying professional liability insurance. Thank you.